Good afternoon. This is Media Center, Ukraine, Odesa. We are starting today with the briefing dedicated to the presentation of the results of the specialized discussion at the Justtalk space about the legislation and prosecution for collaboration work. Our speakers are Onysia Synyuk, legal analyst at the ZMINA Human Rights Center, Yulia Lisova, lawyer, coordinator of the Justtalk space, and Oleksii Arunyan, journalist of the judicial journalism media Graty. They are all with us online today. Onysia, could you share more information about the discussion and its results? Good afternoon. Yes, I believe that this is a very important discussion. And the collaboration legislation was introduced during the first month of the full-scale invasion, but that was an emergency solution to tackle emergency issues. So now we should understand the context. They are the territories that have been occupied for almost 10 years, and they are the territories that have been occupied for 18 years. And the context is constantly different than when these territories were occupied for several days or weeks. So we should understand how to develop practice and how to amend the legislation. That was the main focus of our discussion. We discussed that with the representatives of civil societies, with the prosecutors, with defenders, that is lawyers, journalists, who also cover this topic and can communicate this information into clear format to the public and also the judges. Thank you. Yulia, could you share more details about your practice and about your cases? And I looked through conclusions of the discussion, and it is mentioned that around 800 cases were found in judicial register. Yes, that was the result of the survey that was presented during the discussion. 800 decisions were found, and they have been then analyzed by ZMINA Human Rights Center. And I would like to start with explaining why discussion is needed, and not only activities of lawyers, because this is a very important and complex problem, which is how to use legislation on prosecution for collaboration work. That's why it is very important to organize such discussions, to find consensuses, to find common understanding and solutions, and this is the task of Justtalk. As for the practice, as for cases, I'd like to say that the main problem when it comes to legislation on prosecution for collaboration is that the lack of clarity in the legislation, and this leads to a subjective approach. And how it will be applied depends on a judge, on their beliefs, on the understanding of this legislative norm. And this should not be like that, because the law should be clear. It should have a clear, rigid framework of its application. And this is important to work out the results, and this is important for reintegration processes, because people who are on the temporarily occupied territories should understand and foresee counteractions in terms of their possible prosecution. But the cases that we have, unfortunately, show the contrary. There is a very thin line between collaboration activity and the state and the article on the state treason. In some cases, holding a state job on the occupied territory is interpreted as the state treason, but we can see that in other decisions it is considered as collaboration activity. And common people can say that there is no big difference, that this is important just to prosecute. But I would like to make an example. If some actions are qualified as collaboration, for example, under Article Section 5, Article 11, this is like 5 years of imprisonment. When it comes to high treason, it could be a 15-year sentence or a life sentence. This means, and we should understand this, that the legislation is of poor quality, and it depends only on law enforcement bodies, on an individual prosecutor or judge. And then the sentence will be at least 15 years of imprisonment, or it could be collaboration. This is starting from 5 years of imprisonment. One more problem that we can now see in sentences, they are not well coordinated with international standards, including Geneva Conventions, which are directly related to the situation that we have been facing. In the Geneva Convention, it is allowed for people to continue working on the occupied territories just to ensure the processes which are essential for people. But unfortunately, in sentences, we can see different situations. For example, when people are sentenced because they worked in utility services, or those people who are rescuers or work in fire brigades. So they formally, yes, they just hold the job of the occupation authorities, but these activities were aimed at ensuring proper lives of people. And here I would like to speak about the gaps in this legislative norm. So everyone could be sentenced under this norm. This could be a worker of a food store or so-called mayor. So all these people will be prosecuted as collaborators. And we should send clear signals to the population in the temporarily occupied territories in terms of specific crimes and the normal work and life. For people not to be worried that after liberation they could be prosecuted for their activity. But if people decide to collaborate against Ukraine, there will be criminal liability. That's all. Thank you. Now I would like to give floor to Oleksii, but we have already received several questions, and I would like to ask them once again. Do you plan to publish a recording of this discussion? Because a lot has been done, and journalists is asking if he can get this recording. Perhaps this is the question to Yulia or Onysia. As far as I remember, we recorded the session. And Oleksii, the floor is yours. Yulia has mentioned the cases of prosecuting people for collaboration, those people who are not related to state activities. And if I'm not mistaken, Graty covered such a case. Could you share more details? Yes, Mikhail, but I would like first to explain how I am related to this topic. I am a journalist of the judicial journalism media Graty, and we have been covering the criminal prosecutions, which are important for the whole of society. And now we are focused on covering criminal proceedings and prosecutions related to the war, including those related to collaboration. At the beginning of March, I decided to focus on the Donetsk region. Why was it so? This is a strategic area of activity of the armed forces of Ukraine, and we all hope that those territories will be deoccupied. And when it happens, there will be the question to the state policy with regard to people who have been staying there for quite a long time and cooperated with the occupation authorities. And there are a lot of such people because these territories have been occupied for a quite a long period of time. So we need to understand what state policy we could expect there. And at that moment, only 2 cities had been occupied, that is the Donetsk region, Svetogorsk and Liman. So I decided to focus on Liman. Liman was under occupation for 5 months. And the so-called Donetsk People's Republic tried to establish occupation administration there. And different enterprises and public enterprises were involved in the process. So what happened after the occupation? We analyzed criminal cases that were initiated after liberation of those territories. And there are quite a lot of them. As far as I remember, there were around 8 suspicions in Liman. The cases were considered in Dnipro since the Liman court was destroyed as a result of hostilities. So we monitored those cases for around 6 months. And I visited Dnipro, communicated with prosecuted there. I also visited Liman to discuss this topic with local population and local authorities. And as a result, I published several articles about how people collaborating with the occupation authorities are prosecuted. There are different areas. Here are different groups. We can speak about the first group, the group of people who held managerial jobs in communal enterprises, so those services dealing with the restoration of power, gas and water supply, etc. It should be understood that the hostilities fully destroyed Liman. The population was 23,000 people before the occupation, and there are still 10,000 people in the city of Liman and in the Liman territorial community, and they had to survive somehow. So when the Russian troops left Liman and the Ukrainian army liberated Liman, pro-Russian people who deliberately cooperated with the Russian authorities left together with the Russian troops. And I communicated with a lot of people who were blamed for collaboration, and I could not find people who collaborated deliberately. People answered that they just held those positions because they needed to earn money somehow under the occupation, because they needed to buy clothes and food. And when it comes to utility services, someone had to restore the city. And there was one of the case of my focus, and it was around electrician who was the head of the service restoring power supply during the occupation. And he told me that he agreed to get that job because he had to earn money for his family. That was the first reason. And the second reason is that the town, the city, needed power supply. Without that supply, it would be really very difficult for people to survive because a lot had been destroyed there. And this article envisages different type of sentences, as imprisonment and probation period, and also fine. And the court was rather formal about that case. Defenders provided a lot of facts during the process. And the local lawyer from Liman defended those electrician. He's pro-Ukrainian. He was captivated by Russians. He was tortured there, but he decided to support that electrician in question, believing that the second chance should be given to that person. And the electrician, he just acknowledged his guilt, but he asked him not to punish. But the decision of the court was the 3-year imprisonment. And that was the first level. And as I can see that the courts of the first instance, they are very formal about such cases. They do not consider all the details. But as for the second instance, those courts are more precise in decision-making, and the quality of their decisions is better. This is like the general conclusion. More information, more conclusions can be found on the website of our media, Graty. Onysia, there is the question from journalists of our media center. Are there any appeals, concluded one, softening the sentences in cases just mentioned by Oleksii? Yes, thank you very much for this question. This also shows some trend in these cases because when it comes to collaboration article, there is only one appeal on behalf of a defender and not the prosecutor, and one justification. And this is one appeal that has been mentioned by Oleksii when it comes to softening the sentence. And the first instance court did not take into consideration a range of important facts that make this case individual. But in that case, the court did not take into consideration that at the moment the decision on the sentence was made, the person had been imprisoned for some period of time. It also was not taken into consideration that the person was responsible for family revenue. And all these details were considered properly by the court of the second instance. But we can see that this is the only appeal at the moment. It should be understood that in a lot of collaboration cases, there are a lot of agreements on guilt recognition. When the agreement is meant between prosecution and defender acknowledges his or her guilt, but this means that no appeal can be submitted. So everything stopped at the first instance, and as a result, we have what we have when the first instance is more formal about such cases, and there is no competition between different branches because no appeal could be expected. Could I add a bit? Yes, a bit because we have a question. Yes, just a small intervention. My observations: why there are not so many appeals in this area? Because usually when we come back to Liman, people collaborated quite often with the Russians because they didn't have money and they had to earn money. So these are poor people, and they cannot even afford themselves a private lawyer, and they are just defended by the public lawyers from the secondary legal aid centers, and these lawyers do not submit appeals. And this is very bad because we cannot see normal practice here. Thank you. Onysia, have you analyzed any statistics, if it's possible? Or perhaps you just can get this information from prosecutors attending your conference. In Odesa, a lot of cases have been considered with regard to people who just armed forces and they fought against Ukraine, against the Ukrainian army. So there is no doubt in their guilt. And there are cases that have just been mentioned by Oleksii. And do you have any statistics about frequency of different cases? For example, when people are brought to liability and then it is found out that they just wanted to ensure the proper activities, utility services in the occupied places. And here we are coming back to the first problem mentioned by Yulia. There is no clarity in the legislation. That's why it is not clear what activities could be considered as violations and what can be allowed on the occupied territories. This is unclear both for people who are still there on the occupied territories and for those who apply legislation. And all these cases are interpreted differently. For example, Section 4 is related to handing over material resources to the aggressor state. But it is perceived differently what actions can be covered by this section, including paying taxes and receiving salary on the occupied territories. If we say that this is covered by criminal liability, then all people on the occupied territories should be brought to criminal liability. When it comes to the statistics, it is very difficult to just finalize it in terms of clarity of prosecution. According to our survey, this is the first article that does not envisage any serious sentences. And I think that this is the focus of the investigation. The second category, this is non-managerial jobs in the occupation administrations, and this category covers a lot of people from the occupied territories, including such cases as mentioned by Oleksii, some street cases which are not related to the occupation administration, but they are also brought to liability. Those people who just had jobs of the security at school or some other minor jobs. And this is the question: was it dangerous for the society to be criminally prosecuted? And when it comes to the quality of such cases, we come back to what has been mentioned by Oleksii. And we can see the really formal approach to all these cases, starting with investigation, because the system is overloaded, and we know about this. Investigators have a lot of work to do, and there's a lot more than 100 war cases and 6,000 cases when it comes and proceedings when it comes to collaboration. And investigators, they try to cover everything because there is no differentiation when it comes to severity of crimes. Investigators, they try to do everything at once and investigate everything. That's why they find minimal evidence for the investigation. That's why there is a lot of space for error, both during investigation and judicial process. There is the question to Oleksii, but first I would like to ask Yulia. You managed to involve in this discussion the representatives of the General Prosecutor's Office, and I believe that you are very successful. For example, they did not agree to join our discussion today. And you say that the amendments should be made for legislation. When it comes to our experience, there is a group of prosecutors who are concerned about the situation. They are open to collaborate with us, and they are ready to discuss this problem. Because both for everyone, for lawyers, for judges, and for prosecutors, it is easier to work when the legislation is clear. And now we receive a lot of signals from detectives, investigators, prosecutors, and judges how to properly use this legislation. They say that it is important to establish uniformed approaches. No one wants to make a mistake. Everyone understands the importance of this area, and the active legal community is trying to find changes and the proper ways to apply this legislation. It is important for legislators to be able to hear these signals, to take into consideration when it comes to future amendments. Thank you. Oleksii, the question is from Vera Zaporozhets, a journalist. She asks how many sessions you've visited when it comes to collaboration, and how many cases have you started? First, I would like to answer to the first question. I'm also in touch with different prosecutors within these cases, and I can see prosecutors applying formal approach. They just don't care. They just follow the instructions. And other prosecutors don't like the situation. They just concerned about the sentences. As for cases, so there were a lot of 80 cases in Liman, and we just checked all these cases to focus on around 10, to monitor them more closely, how they are considered in Dnipro. And I think that I've visited around 10 sessions for every case. And we also continue our work because the process is undergoing. And the question about the cases that draw a lot of attention of journalists and those who are not that popular. And can you see any impact on the result of proceedings? It is difficult to answer the questions. And according to our legislation, our courts are independent. But I think the judges, they are also citizens of Ukraine, and of course they follow the feedback from the society. And of course, this can have an impact on their decision. And in this context, it is very important to properly cover these processes by journalists. If we just repeat that idea that all people are collaborators and they should be sentenced, of course, this will affect court decisions. But we should also show all the shades in individual cases. And we should take into consideration that it is really very difficult for people to stay on the occupied territories. They are under pressure all the time. And there is the Geneva Convention that establishes the rights of the civilian population under occupation. And people should also somehow support themselves and their families. And this should be also taken into consideration by our courts. And it is very important for journalists to show stories of specific people, of specific accused. And I think that this could have a direct or indirect impact on investigation and court proceedings. As far as I remember, in 2016, when we saw first discussions about collaboration law, different draft laws were considered. And some civic activists said that even those people who are forced to take Russian passports should be brought to liability. But I can see that this is not discussed at the moment. So as far as I understand, we could not prosecute all people who get Russian passports. This should not be like that. When it comes to liability for a passport, in 2014, our state gave answer when the law on temporarily occupied territories was adopted, and there was the norm saying that getting a document from the occupation authorities do not imply any legal consequences, and this means that there is no liability for that, because liability is a legal impact. So in 2014, the answer was given by the state. I think that when it comes to discussing liability for getting passport on the occupied territories and as a manipulation, and perhaps they just try to play with this is kind of a populism. And here I would like to agree with Oleksii, who says about the importance of journalists' work, because the work of journalists contributes to forming the request for justice from the society, and we should respond to that. And we have told a lot today about the formalistic approach to consideration of such cases, and we can see it among the judges, investigators, lawyers, and perhaps this is because they believe that the society wants everyone to be prosecuted, and they don't want to spend much time on that. They just want to meet the needs of the society. But if the law enforcement, legislation, and judicial systems can see a different request from the society, the request for justice, then I believe that the judicial and law enforcement systems will be gradually changed. And of course, the public inquiry could be revolutionarily changed. And the last question to Onysia, and it is mentioned in your report, and of course we will share this report with all journalists through our Telegram channel. Onysia, the cases considered by in absentia, how this practice is correlated to the international practice, and what is the future for such cases if the persons found guilty are not in Ukraine? Thank you very much for your question. But first, I'd like to share some statistics with you. And we prepared some materials for the discussion, and we are going to have some additional survey related to changes, and we are going to publish everything in the nearest future. When it comes to statistics, and in two categories, Part 5, the managerial positions in the occupation administration, and Part 7, these are jobs with law enforcement and also involvement in the military formations fighting on the side of Russia. Almost 50% of such cases are considered in absentia, as well as other categories for collaboration, and we have even more of them now under Part 3, which is related to educational domain. So those who stay on the occupied, teachers who stay on the occupied territories, working following the standards of occupiers. And these are the cases considered in absentia. And a lot of issues here. We should not only think about the opinion of international partners, but we should also speak about the competitiveness in this process, because there is no person who can represent their position. This person should always have a defender, a lawyer representing their interest in court, but this person does not have any contacts with the defendant because and cannot learn about the motives, about the conditions, was it voluntary, or was that person forced? So no information can be presented in this case, and this is also mentioned by the lawyers. They present their clients, but they have no information to present to court. And this is also the question about the notification system for such people. Do people have access on the occupied territories to know that they are accused in some crime? So this is the question to the quality of our judicial process, and also the question of international standards, because when it comes to proper notifying people to be involved in the court proceedings, this is one of the basic principles of criminal justice. So such cases will not help us to form quality practice, and we can have a lot of questions from our international partners. And as a result, this can lead to a lot of appeals, including in the European Court on Human Rights, because there will be people who would like to appeal because they were not properly represented. Thank you. Thank you very much for taking part in this briefing. We'll stop here because the next briefing will be in 15 minutes. With us, we'll have with us Dragan Shormas, former MP in Serbia. And I would like to thank our current guests. Thank you very much for finding time to join us today. Thank you for the invitation, and have a nice day. Thank you. Stay tuned. The next briefing will be in 15 minutes. Watch us on YouTube or just visit us offline.